if I understand it, then I can figure out what to do with it, right? That's my strength. This is what I do. And I can't understand anything because it's too much to understand all at once. So I just want to say to people, if you're also feeling like, how am I supposed to process this and also, make sure that there's bread and toast in the morning, like, I'm with you. Welcome again to Allegedly Golden. If you can't hear it, Frank is snoring just on the other side of me. So if you hear a light ASMR during this recording, that's what that is. We are at episode 9 of Allegedly Golden. I have told myself that after we get to episode 10, I'm going to stop talking about the numbers because it's just sort of a goal that I have to get to 10. So I'm going to keep counting until I get there. And then I will just start calling them what their titles are. But I think it's worth noting that we're at number 9, because that means I'm getting close to 10, which was my goal. And I'm also kind of feeling, I can't believe I've done this many. I'm proud of myself for doing this many, for continuing to do it, for doing it on time, in spite of all the other things I have to do. And, I've learned a lot since the first one, most of which is technology and equipment. I knew that making the content wasn't going to be hard. I'm a yapper, right? I'm a literal professional yapper. Like, I talk people into and out of things all day long. But the technology and the software and the lighting and the stands for things and the locations and all of that, that is the hardest part. And I'm very proud of myself that I have figured most of it out and gotten myself into a groove where, like, it's not as hard as it used to be. If you are not watching this on video, I am still moving around trying to find the best place. I don't have a dedicated studio right now, and I'm really trying to decide whether I want one, or if I do, if I only use it for some things. Because one of the things I really don't like is when you go to somebody's channel, if it's a video type platform, and you just see the same background over and over and over again. Like, I get that you want some consistency, but I also I don't know, I feel like it kind of reduces the content creator to that one thing. And I like being able to move around. I like being able to be in different parts of my house that are sort of different parts of me. So, I like it when you guys give me feedback about where I am. Tell me if you like where I am right now. I'm in that kind of usual space with the big picture behind me, the big painting behind me. But as I'm figuring this out, one of the things I'm figuring out is that I don't think I want it to be static. I don't think I want to just always be podcasting from the same place, because that's not the way I live my life. And I don't think that's the way I should live my podcast either. I have had a week that I don't know how to describe. And I don't know if I'm going to articulate this well, but I'm going to try. Because I think a lot of us are having this experience. Everything is happening, and at the same time, nothing is happening. The world is big and complicated, and we are in just a deluge of information, some of which is good, some of which is bad, some of which is horrific. And it is too much to process all at once. You've got all the things that are coming out all over the world about the files, but we also have the Olympics. Like, that is just too many. It's too many things about too many things all at the same time. Plus, we're all living our normal lives with all of the people and the places and the things we have to do. And I just have had a very difficult time this week getting any thoughts to really form completely, if that makes any sense. Like, I'm not super angry, but there is anger. And I'm not super excited, but there is excitement. And I'm not super depressed, but there is sadness. And I'm not terrified, but there is fear. It's all like simmering in there. And by in there, I mean my head. And I don't know how I feel about a lot of things. I'm having, sometimes things happen in the world and I'm like, well, that's good. That's bad. That's great. That's terrible. That's what I wanted. That's what I didn't want. And right now, there's just so much that's happening just in society in general. Like, watching the Olympics and seeing how many female athletes are absolutely fucking killing it out there. Young women who are not weighed down by at all the expectations that I was weighed down by and that my generation, and God help me, my mother's generation was weighed down by. This freedom and this ambition that they have and this unapologetic attitude they have is so inspiring to me and so fantastic. And it just does something to me, like fills me up in some way by watching it. But at the very same time, I'm also seeing all this information about how many women have been tortured and victimized in ways that could have been prevented. And it's really hard to reconcile those two things together. And that, I don't think that should be a political statement to say, like, how do I process all of that? Nothing fits cleanly in any little box. Nothing fits cleanly. You can't just put things in buckets. This good, this bad, these people. Like, it's way more complex than that. And I've been saying for about 20 years now that being a woman in this timeline just feels to me like every day you have to redefine for yourself what you think being a woman is. Because it changes all the time. And the transition is good as long as it transitions to something, right? But I have felt like every day of my life, if someone said, like, what's it like to be a woman? I would have a different answer, depending on what's happening to me, depending on what's happening in the world, depending on how I feel as a mother, depending on how I feel about the way I look, right? Like, it changes all the time. And I feel like in the last week or two, that has gotten even more so. It's like multiplied. And so I don't really know where I think I fit in the world or what I want the world to be or how I understand the world. And I've been really struggling with that because that's where I find safety is if I understand it, then I can figure out what to do with it, right? That's my strength. This is what I do. And I can't understand anything because it's too much to understand all at once. So I just want to say to people, if you're also feeling like, how am I supposed to process this and also, make sure that there's bread and toast in the morning, like, I'm with you. I'm with you. In fact, I think I probably am leaning into personal family stuff even more because it's more simple in a way, right? Like, I tend to like big thinking, like, oh, let's talk about this, crazy issue. And like, I'll see a video and it's like, they've discovered a new kind of tear in the solar system. And I'm like, well, now I have to know everything about that. I'm usually that way. But this week I've been like, you know what? I just want to go sit with my kid and help him with his homework. I just want to go do things that feel good in the moment, because that is what's keeping me sane. I just want to go watch like medium to bad television because that's going to make me feel better. So if you're going through that, I just want to say I'm going through it too. And I am typically someone who thrives on big problems and lots of information and big ideas. And right now I want nothing to do with those things. My brain is telling me, my body is telling me, not now. Let it marinate, let it sit. You'll figure it out. I also just want to follow up on a TikTok I made late last week that was stitching a TikTok that's gotten a lot of stitches. It was a younger guy saying, can the 40 to 60-year-olds please just take over? And he's being cute about it. He's like, we fuck with y'all. We like y'all. Can y'all please take over? And I was one of the many Gen X late millennials who was like, no, we're not doing that, and detailed why. And it seemed like it resonated with a lot of people. But I've been talking to so many of my friends, and a couple of you made these comments on my TikTok, and it really got me thinking about it. There are so many of us, especially women, although not exclusively, who were so ambitious, right? We were like, we're smart and we're ambitious and we're going to go out there into the corporate world, or we're going to be entrepreneurs. And we know we can do everything men can do. And we know that we're strong and we know that we're powerful and all of that. And over the last handful of years, we have all realized that like the leadership level that we've been striving for, we don't want. Because we've seen how other people do it, which first of all, looks like it sucks a lot of the time. But it also means cleaning up a lot of bullshit that you didn't cause. And, you know, there are so many women in my life, friends and colleagues and former colleagues, and sometimes like a person I will meet at a dinner. And we will just get to talking like, yeah, I thought I wanted to be in the top slot. And now I'm just like, no, thanks. I think that professional women, all women work, but professional women are figuring out, or at least a lot of us are figuring out, that power and leadership in the traditional sense at work is a headache. And it's probably more headache than it's worth. And I think that's even more true for those of us who have gotten to like the next level down from that, who are at like second banana place. And it's like, I mean, I'm pretty much doing what that does, except I don't have the authority. But like, I don't want to do that. I don't want to keep dealing with this BS and cleaning all this stuff up and giving people terrible news and telling everybody what management's, decisions are and having to pretend like I agree with them, even though I don't. But now I have to, because I'm at that level. I have to pretend like it's a good thing. So many of us don't want to do that. And I have probably 5 or 6 like close girlfriends, and we are all at that level. And I have independently had conversations with all of them where we're all like, yeah, no, I don't want it. And I think it's partially a recognition that it isn't worth it. I think it's also after you've been in a professional atmosphere for a while and you recognize that not all of them are, in fact, meritocracies where the best people rise to the top. You know that once you get to the top, that doesn't necessarily guarantee that everybody else at the top deserves to be there. And it's not, it doesn't have the shine on it like it once did. When you're younger and it's like, oh, well, if they've gotten to that place, it must be because they're great. And now you know better. So I'm going to keep exploring that idea. I'm going to figure out if there's someone who's written any books on that, or if there's any other, content out there on that, because I am seeing this shift in my life with my colleagues and my friends. And I know that's just anecdotal, but I touch base with a lot of people because of the kind of work that I do. I talk to people about their work all day. And it is not an exception. It is becoming the rule that women of my generation, and to some degree, even the millennials, are like, I'm not trying to get all the way to the top of the ladder. The top of the ladder is a trap. I'm just trying to get to a place where I feel like I can do what I like and have enough autonomy that I can live my life. And that would be a humongous shift in the American workplace if all of us say no to that. So if you have any particular insights or articles or books that you've read on that, please let me know, because I'm really going to start looking into that issue. I'm fascinated by it. So it's time for some civil disorder, which is our general roundup of what's going on in civil cases that are high profile or involving celebrities. There's nothing really happening in the Lively Baldoni case, except that we are now on full order watch. on the motion for summary judgment and the motion for judgment on the pleadings. Now that the settlement conferences have happened and neither case settled, every day it becomes more and more likely that Judge Lyman is going to issue an order. I am asked every day, does he have a deadline? And the answer is no. He does not have a deadline. He just has to do it before trial. But he will probably do it sometime in the next handful of weeks, because once you get to about 60 days out from trial, people have obligations that kick in about exchanging exhibit lists and witness lists and preparing jury instructions and all that kind of stuff. And that is very intense work. And you want to know which claims are going to trial, if any, before you start doing that work. So my guess is we're going to get that before spring break. That would be my guess. But technically, he's a federal judge. He can do what he wants. The most interesting thing that was going on in this past week for me is this social media trial that is happening in California, that is now just against Google for YouTube and Meta. Adam Mosseri from Instagram testified, and then Mark Zuckerberg testified last week. And, we couldn't see it. It's not being live streamed, but we've all seen Mark Zuckerberg testify in front of Congress. And he's real bad at it. And he admits he's real bad at it. This is not his cup of tea. And no matter how much you prepare somebody, if they're not, if they don't have those kinds of skills, it's pretty hard for them to come off as genuine and authentic. But, I think that he probably did the best he could with what he's got. From what I could read, in terms of the reports from the reporters who were in the room, Zuckerberg, and I've heard him do this when it comes to adults, but I was surprised to hear that he's making the same argument when it comes to children and social media. Zuckerberg kind of relies on this argument that is very similar to the argument that the NRA makes about guns. That we just make the product, but the harm is caused by the people who use it. Right? And so Zuckerberg has always kind of made this case that we are just creating a platform, and it is not our place to say what you can and can't do on that platform. But we cannot be held responsible for simply creating the platform when the users are the ones who cause the harm. And again, I get that when it comes to adults. When it comes to adults, I don't totally agree with him, but I'm closer to him on that one, where it's if people are stupid and they don't pay attention and they, don't follow the rules and they use it, in ways that it wasn't intended. Okay, I'm a little bit more lenient on the social media companies in that regard. But when we are talking about children, the idea that the social media companies are not going to regulate how minors use their platform. And we know that minors, because they're minors, can't regulate themselves. What Zuckerberg is really doing is putting the blame on the parents and saying, if you let your kid use these products to their detriment, that's on you, not on me. And I'm not so sure how that's going to work in front of a jury. As an overall matter, this trial is really important, obviously, because there's 1,000+ plaintiffs who are just like the one in this case, who have filed cases like these. And whatever happens in this first case is going to determine to a great degree what happens with all the other cases. Are they going to, if the plaintiff wins, are they going to settle all the other cases? Is there going to be a change from Congress? Is Meta going to, or all these companies going to voluntarily change some of their algorithms? What is going to happen? But the thing that just never is out of my mind is it's almost like the Van Zandt stuff when it comes to Lively Baldoni. There are a lot of things in this world that aren't necessarily violations of the law, but it doesn't mean it's the right thing to do. And I don't mean applying someone's religious or moral values to everybody else, because I don't think we should be doing that either. But when it comes to technology, So many of these things were invented and put out to the public by these companies because they could, without anybody thinking about whether they should. And when you've got a platform and there is evidence in hundreds of cases that even if you don't believe it takes you all the way to liability, there's still evidence that the use of filters has caused young women in particular to develop eating disorders and body dysmorphia and all kinds of other issues. I just don't think the defense of, well, we didn't want to stop anybody from using it. I mean, it's their choice. I just am not sure that's going to work. And, you know, we're going to keep going in this case and they're going to keep putting on evidence on the plaintiff's side. And then I guess at the end of the plaintiff's case, we're going to hear from the plaintiff herself, who was the young woman that this happened to. But I was very surprised to hear that Zuckerberg didn't have a better line of argument, to be honest. I thought, you know, that guy's got hundreds of lawyers, the best in the world, and lobbyists and communications people and PR people. And the best they could come up with is like, well, we can't control the world. The best they can come up with is we didn't want to censor people. We're not talking about censorship of people talking about politics. We're talking, it's not censorship to disallow minors to use dangerous technology. I can't see how that just as a narrative is going to work. But on it goes. We'll keep watching the case. I look at the reporting every single night, and I'll keep telling you guys how it's going. But from what I have seen so far, it is not going great for the social media companies. And everything they say, you know, every argument they try to make for, well, we thought about that, but we decided not to. Well, we thought about that, but we decided not to. I think the fact that they thought about these things, it's not like they're saying, oh, we didn't know. We didn't have any idea that that could hurt young people. We didn't have any idea that that could lead to suicidal ideation. We didn't have any idea. They knew, but they made a business decision to leave it as it was. And when you start looking at how to prove negligence, which is the cause of action and the failure to warn that the plaintiffs are using in the case, knowing about it and making a choice not to do anything is sort of the definition of negligence. So I'm going to do a video sometime this week sort of on that case altogether and looking at what they have to prove and explaining all of that to everybody so they understand the verdict if and when there is one. But I just don't think Mark Zuckerberg did anybody any favors. And I think that's probably exactly why the plaintiffs called him to testify, because they knew that he wouldn't be able to make anything out of it. And I don't think he did. There was a Zoom hearing this week in the Karen Reed wrongful death matter, the one in Massachusetts State Court where she is being sued by John O'Keefe's family about an inadvertent email that was sent. I did a video on it. You can watch it on any of my channels. They recorded it and I was able to watch it afterwards. And my takeaway from that entire hearing was that the O'Keefe family's lawyer sucks. He is not good. He was not good on the law. He was not good on the facts, and he was not good on the argument. He was not good. He seems to be quite flummoxed at anything that is brought up that is not exactly what he thought was going to happen. And I'm not sure he's doing the O'Keefe family any favors. The judge did not rule, but I don't expect it's going to go very well for that lawyer or for the O'Keefes. In a case that I've been sort of kind of following, Demi from Secret Lives of Mormon Wives filed a motion to dismiss in her case where she's being sued by Marciano for the things she said happened at the villa. She claims it was SA. He says that's not true, and that's defamation. She has filed a motion to dismiss that is essentially an anti-SLAPP motion, which hold on that because I'm going to talk about that in legalese in the next segment and explain what that is. These are motions that have been used in, I think, 4 or 5 cases involving high profile people that I've talked about just in the last year. They get used all the time. And I want to talk about how they work so that people can decide for themselves whether they think they're good or bad and what kinds of cases they should be used in. But she filed one there in federal court in Utah. She is asking the judge to throw the case out, saying that it is an attempt to stop her from engaging in free speech. In the Jones versus Abel case, the companion case, one of the companion cases to the Lively Baldoni case, we learned that Stephanie Jones, or her team, inadvertently, so they say, forgot to turn over 13 documents to Wayfair and Discovery that have to do with Jones and Jones Works damages in the case, because remember, she does have her own claim, so she has to prove damages. Apparently, these 13 documents were attached to an expert report for an expert they hired, and they sent the expert report over to Wayfair, and Wayfair's like, thanks for the report, but what are these 13 documents that are attached? We've never seen them before. So they gave them to the expert, but not to Wayfair. So Wayfair agreed. They jointly asked the court, let's reopen Discovery for the limited purpose of allowing us to ask some questions about this. And the judge said, yeah, that's fine. So we'll see what those 13 documents are. My guess is they're about lost opportunities on behalf of Jones Works clients. She lost things like that because that's what her damages would be, because all of her damages are reputational damages. I just want to tell you guys that I am fully aware that there are a lot of really big U.S. Supreme Court cases. This is the time of year when all the big cases come down because the court's session is coming to a close and they save all the big ones until the end. And I know that that really interests people, and I want to be of service without wading into, number one, political waters, and number two, into other people's territory. There are really good content creators out there who are making podcasts and content on Supreme Court decisions. Preet Bharara, who used to be the U.S. attorney in the Southern District of New York, the women of Strict Scrutiny are fantastic on Supreme Court. There are multiple different podcasts out there, mostly of ex-Justice Department or government lawyers. And so I don't need to saturate the market with more commentary. I do, however, think that there are some things that I can probably simplify with my way and my style to just let people know what's actually happening in those cases without getting into the political implications. I really do believe that you don't have to tell people what their political values or beliefs should be. You just tell them the information and let them decide for themselves. I think one of the problems that we have right now is that people don't have all the information. And so people will hear, oh, the Supreme Court did this. And sometimes that's not actually what they did. Or sometimes it sounds terrible and it's actually not that bad. Sometimes it's actually good. So I'm trying to figure out the right way to do that. I want you guys to know that that is on my radar. If you have feedback on that, if there are things in particular that you want to understand, that you feel like you don't get about the way that that works, leave comments on any of my platforms, and I will read those, because that is one sort of element of this, and it feels weird for me not to do it. Because it's out there and it's such a big deal, and I've done appellate work and I'm fascinated by it. And I think that's where all the real meaty issues are. But I also don't want to delve into a realm of like, this person sucks and this justice is terrible because they're aligned with, I'm not doing that. That's not what my content is. There's a lot of really, really good people out there who do that, and God bless them. But, if I can say like, this is a 1 paragraph explanation of what this actually is, maybe that can provide some value. I will tell you, one of my, I think very, it's not even bipartisan, it's nonpartisan beliefs about the U.S. Supreme Court is, that I think we should all be in agreement on. I don't understand why we're not, is that it should be bigger. The idea that there are 330 million people in this country and 9 people make all the decisions is crazy to me. The Constitution does not say how many people it has to be. It can be bigger, it can be smaller. It has been bigger, it has been smaller. It probably needs to be an odd number so that you don't have ties. But that is just one thing that I find is absolutely insane, right? 9 people, that's like, I don't even know what 0.00001% of the American population that is. I think that's crazy. But let me know what you think about all that, and I will start looking at those and figuring out how I can talk to you guys about those cases. So for legalese today, we are going to talk about this specific type of motion that gets used all the time in high-profile cases. It is currently being used in 4 cases that I am following. The case involving the Pitt, the TV show, where the makers of the Pitt are being sued by the estate of Michael Crichton, who's the creator of ER. The case involving Baby Reindeer, the Netflix show, where the woman who says that the character in Baby Reindeer is based on her has sued Netflix. The Karen Reed civil rights case in federal court, the one where Karen has sued all kinds of people, including the McCabes, the Alberts, and Brian Higgins. It is being used in that case. And now it is being used by Demi from The Secret Lives of Mormon Wives. So what is this? Why do we keep seeing it? And how does it work? So if you follow my content at all, you know that my biggest beef with this kind of law is the name. It is a double negative, which I hate. So SLAPP, SLAPP, is supposed to stand for Strategic Lawsuits Against Public Participation, meaning this lawsuit was filed for the purpose of shutting people up. And so an anti-SLAPP law is supposed to be anti-stopping people from speaking. So it's anti-anti. So it is, in fact, a pro-free speech law. And I am going to refer to it as that. Pro-free speech law. Because what it intends to do is protect the rights of Americans to engage in free speech without worrying about being sued so that somebody can shut them up. That's the purpose of these laws. Right now, they exist in 30 states in DC. There is no federal pro-speech law at this point in time, although there has been one proposed, I believe, in the Senate. But right now, it is just the law of 30 states and DC. And some of the laws are more powerful than others. This is very much a situation where even though 30 different states and DC have these laws and they all call them versions of the same thing, they all have very different language and they all have very different ways that they operate. They are on a continuum. But they were all passed because the legislature in each of these states bought into the idea that, like, free speech is like the number one right in America, right? Being able to speak freely, that's kind of like the basis for everything else, with which I agree, by the way. If you don't have the free speech part, none of the rest of it really works. So we need to protect speech. And what these laws were intended to do was to help the little guy. They were supposed to protect the little guy from the big guy. They were supposed to protect David from Goliath, because Goliath had the money and the power to use the courts to shut David up. Sometimes it was the media, sometimes it was individual speakers, sometimes it was artists. But the idea was that through defamation laws and other kinds of laws, invasion of privacy laws and other kinds of laws, people who had the money and wherewithal to hire lawyers could use the court system to shut down speech from people who otherwise would have the ability to speak freely. And that is an abuse of the court system, and there needs to be a way to ferret that out in a case as early as possible. And in most circumstances, to throw a case like that out as early as possible if it's in fact intended to shut somebody up. So it's a good idea, right? I mean, it's a good theory. California was the first one, I think in large part because so much art happens in California and art is free speech. And so California had the first and arguably has one of the strongest of these pro-speech statutes. But like I said, some of them are stronger than others. Some of them are more specific than others. But everybody's legislature decided we need a mechanism to stop people from stopping people. That's why it's a double negative, right? We need a mechanism to figure out these sort of frivolous claims early and have them thrown out, above and beyond the mechanisms that already exist in the law for people to throw out cases early. So in every civil case, there's always the opportunity to file a motion to dismiss, but your basis is really limited. Your basis is this complaint does not state a claim upon which relief can be granted, and there's a million different ways that you can argue that. But what these legislatures decided in passing these pro-speech laws was that's not enough. This is such a big deal, and speech is so important that it needs to have its own process, a totally separate process from everything else, so that we can get on this stuff early. And if a case has only been filed to bully someone into shutting up, the court can rule on it and get rid of that case as soon as possible so that speech can be protected. This was especially important for the defendants, the speakers, who don't have the money to fight a court battle, right? Yeah, you can always wait and say, well, we'll go through discovery and we'll see what happens and we'll see if we can deal with it at summary judgment and the truth will come out. The problem with that is when you're talking about power, when you're talking about Goliath versus David, David doesn't have the money to go through a whole, civil litigation, especially if they're up against Goliath, right? That can cost millions and millions of dollars. Same thing with the media. If a case is filed against a media organization, particularly a smaller media organization, that case can have the effect of having the media take down their story to stop them from reporting. And we can't wait months and months and months for discovery to happen. So that was the intention of these laws in the first place, which, I think was good intent. We'll see if it still applies. The primary target of most pro-speech laws is defamation claims, right? And that is because defamation is one of the only exceptions to free speech in terms of civil claims. It is very hard to sue somebody for engaging in speech. You can sue people for engaging in conduct, but it is very hard to sue people for engaging in speech. It has to fit into a very narrow set of categories because of the First Amendment. And the main mechanism that people use to do that is suing people for defamation, saying, yeah, you engaged in speech, but the things you said were about me and they were false and I got hurt because of it. So to the extent that these laws are aimed at particular types of cases, those are probably the main types of cases that they were built for, which is, I think, one of the cases I'm following now that is the closest to that original purpose is probably Demi's. Demi has been sued for defamation by Marciano for something she said on a TV show. And her argument essentially is, I'm allowed to say what I want to say, and you can't stop me because you can't go to court to try to stop me from telling my own story about things that happened to me. That is my free speech right as an American. So it's probably the closest one in terms of what the laws were intended to do. And depending on the language of the particular statute, because again, different states say things in different ways, it can be used for more than defamation, or it can be used for less. California's is incredibly broad. New York's is incredibly broad. Colorado's is incredibly broad. So it doesn't just have to be a defamation claim. It can be all kinds of different claims. And if it butts up against speech, you can file one of these pro-speech motions. Whereas in some states, it has to be defamation or it has to be certain kinds of speech for it to work. One of the weakest pro-speech statutes in the country is in Virginia. They've had one of these on the books, and they changed it in 2023. They updated it, but before 2023, it was really limited. You could only file one of these pro-speech motions in cases involving like business conspiracy and tortious interference claims, business type stuff. It wasn't built to combat defamation claims. It wasn't built to combat sort of public speaking claims. And that is one of the reasons why Johnny Depp sued Amber Heard there. Because if he sued her in California, where they have very strong pro-free speech claims or statutes, that case might have gotten thrown out. But in Virginia, their law at the time, their pro-speech law at the time, didn't cover defamation. It's one of the reasons they filed there. And they were able to establish jurisdiction there because the op-ed that she wrote was in the Washington Post, which gets published and printed in Virginia. That is actually the case that I use to teach my students about how personal jurisdiction works. But if you want to know why Virginia, of all places, did he sue her there when neither one of them lives or works in Virginia, that is one of the reasons why. Because the pro-speech statute there is very weak, or was. It has now been updated. So when you talk about a stronger statute, like what do I mean? If it's a stronger law, it's more speech protection. What does that mean? What that means is that the law says in its own words, you can ask to have a whole bunch of different kinds of cases thrown out if you think they are a speech problem. And it gives you a much broader category of what those things can be. Like, it doesn't have to be political speech. It doesn't have to be defamation. It can just be anything that has public interest, which is a very, very broad concept in the law. Anything that anybody cares about. The stronger laws, they also work faster. Not only do you file these motions really early in the case and say, I want this thing thrown out, some of them even require the judge, like, you have to have a hearing on this within X number of days. It requires it to go faster to get the court to rule on it faster. The stronger laws also will sometimes automatically put a stay on the case. No one's doing discovery. No one's moving forward until this thing gets decided. The stronger pro-speech statutes also allow, when the judge is determining whether to throw a case out because it is a speech problem, they allow things beyond just the complaint in the case. They allow evidence, declarations, affidavits, documents. The stronger ones allow the judge to look at more than just what has been put in the complaint. The stronger ones also have fee shifting provisions, meaning that if the person who's been sued gets the judge to throw out a case and say, they just filed this to shut me up, here's my motion under this pro-speech statute, and the judge says, you know what, you're right, I'm throwing the case out, the strong ones will also require the plaintiff who filed the case to pay the defendant's attorney's fees. Right? That's a strong one, is you're going to shift the fees. So, you know, if you lose, you don't lose anything. I mean, if you win, you don't lose anything. And also the strongest ones have an immediate right to appeal. That if you lose, it will immediately be appealable, even though typically you have to wait until the end of the case to appeal something. And that is what's happening in two of the cases involving TV shows that I'm going to talk about in a minute. So generally, when a plaintiff files a civil claim, the standard is really low to keep that case going. All you have to do when you file a civil case to keep the case going and get yourself into discovery where you can start finding information is you have to state a claim upon which relief can be granted. You have to allege facts and legal allegations such that if you're able to prove everything that you have said in your complaint, you would be entitled to some sort of relief under the law. It's a very low bar. What these laws do, what these pro-speech laws do, is they raise the burden for the plaintiff. The defendant says, you know what, because I think you are just using this litigation to shut me up, You are using this litigation to come after me for engaging in my free speech under the U.S. Constitution and whatever state constitution they're in. You not only have to prove that you have stated a claim upon which relief can be granted, you have to prove additional things. And so it raises the burden for the plaintiff, and they have to have this whole proceeding, this whole hearing, sometimes with evidence, to prove that their case is more than just trying to shut somebody up. So it can be a very good tool for someone who feels that they have been sued simply for somebody to shut them up. It also delays the case. It stops everything in its tracks, and it can be very, very expensive because it's a whole other process. So the idea behind these laws is to protect speech, to keep the courts from being used as a way to shut people up, right? So let's go through the 4 cases that it's currently being used in, and let's see if it's doing what it's supposed to be doing. So let's start with the Karen Reed civil rights case. She is suing Proctor, Buchanan, Tully, and then the McCabes, the Alberts, and Brian Higgins, claiming that there was a conspiracy between them to rob her of her civil rights by lying to the police, by setting her up for John's death. And the McCabes, the Alberts, and Higgins, I keep saying the Higgins, but it's just Brian Higgins, filed one of these pro-speech motions and said, she is trying to sue us for talking to the police. And talking to the police is protected speech under Massachusetts law. What's interesting about that is that the Massachusetts pro-speech law is very narrow, but this is the one thing it covers. So the Massachusetts pro-speech law says you can bring one of these motions if you are being sued for things you said to the government as part of its official government function. It doesn't even apply to journalists in Massachusetts. A journalist couldn't file this kind of motion and say, you're suing me to stop me from reporting on something. So these citizens are using this. They're asking the judge to throw the case out to say, we are essentially being sued for engaging in free speech. And that free speech was talking to the police, which is exactly what this statute is supposed to protect. Now, I expect what the response is going to be from Reed is it doesn't apply if the speech is lies. If you're lying to the police, that doesn't count. And I don't know what the standard of proof would be at this stage, but the Massachusetts law does seem to apply to exactly this type of situation, the way that it is written. And, in terms of like who's David and who's Goliath in that case, I don't know. I'm sure that they each see the other as Goliath and themselves as David, right? I'm sure Karen Reed is like, I am the little one here. I'm the small one here. I had my life turned upside down. I had everything ruined. I've been through the ringer. I lost my house. I lost my job. I lost everything. But I'm sure the McCabes and the Alberts and Higgins are like, you're the one who has all the fancy lawyers. You're the one who has all these people filing suits for you. You're the one who's famous. You're the one everybody loves. We're just regular people who got caught up in this mess. So it's kind of hard to say where the power balance is in that particular case. I think the ones involving Netflix and HBO are the ones that are giving me pause. So tell me what you think. So in both cases, it's almost identical, the way that these have gone. A lawsuit was filed by the widow of Michael Crichton, who invented ER, against the people who make the Pitt. Long story short, I have videos on it on my channels, claiming that the Pitt is derivative of ER, which that's a whole other argument. And that's violating a contract that Michael Crichton had with some of these folks. They immediately filed one of these pro-speech motions because in California, the making of television is free speech. It's very well established there. and said, she's just suing us over free speech. She's trying to shut us up. She's trying to shut the show down. She shouldn't be allowed to do this. And the trial judge looked at all the evidence and ultimately said, I think it's a close one, but I don't think it's just her trying to shut you up because we do have a contract issue here. There is a legitimate contract issue. So they denied the motion, and the people from the Pitt immediately appealed it, and it's sitting on appeal. Almost the exact same thing happened in the situation involving the Netflix show Baby Reindeer, where the woman, Fiona, who claims that the character in is it Fiona the real person or Rebecca the whatever? The woman who claims that she was the person portrayed in the Baby Reindeer television show sued Netflix for defamation and said, you have something at the beginning of that show that says this is a true story, and people have figured out that this is me, and some of the stuff you said that I said or said that I did is not true. You have defamed me. Netflix did the same thing the Pitt people did, immediately filed one of these pro-speech motions and asked the court to throw her case out and says she's just trying to stop us from making television, and television is free speech in California, and you should throw this thing out. And again, the judge said, it's close, but I don't think that's all she's doing. There's more to it than that, and denied the motion, and they appealed. So both the Netflix case and the HBO, the Pitt case, are both on appeal right now. Now, I agree with them that, TV is free speech. Art is free speech. There should arguably be a higher bar for suing somebody for engaging in artistic expression. I'm down with that. That's cool. My problem here is that these laws were intended to create protection for David versus Goliath. But in these cases, Goliath is the one that's using them, especially in the Baby Reindeer situation. This is an individual person in Scotland suing one of the biggest, if not the biggest, streaming company in the world. And they are saying, you should just throw this thing out. It's not even worth it. So I'm not sure how I feel about these big, wealthy, powerful companies who have tons of lawyers and tens of millions of dollars to spend on litigation using these statutes that were supposed to help the little guy. I'm not sure how I feel about that. And I've been trying to do the thought experiment of, would I feel differently if the studios that were being sued were like a small independent studio and not Netflix or HBO, right? If it was a small independent studio and someone was trying to stop them from putting out a movie or a show because they felt it put them in a negative light, would I want them to be able to use it? Maybe. I don't know. Let me know what you guys think. But this is one of the things that concerns me about these laws, is that they were devised for a certain purpose, which was to help the little guy, particularly the little guy who was engaging in public conversation, make sure they didn't get caught up in court over exercising their constitutional rights. But I don't know how much we're helping the Constitution by having Netflix or HBO throw out a claim by an independent person because they don't like the way that they were portrayed. Not real sure if that's the right idea. Last but not least is the latest one, which is Demi from Secret Lives of Mormon Wives, who has filed one of these motions, as pro-speech motions, in her case with Marciano. Now, Marciano is suing her, and if you don't know who these people are, congratulations, you're lucky. I actually really like the Secret Lives of Mormon Wives. I don't really like the Housewives. I haven't for a long time, but I like that show. There's just something about them being Mormons. I don't know. I just find it fascinating. And Marciano is, I guess, he's been on other reality shows, Vanderpump or something. I don't know. He doesn't do it for me. But they were at like the Vanderpump villa, and she claims that he touched her in a way that she didn't like. And so she went on the show and started saying he SA'd her. He sexually assaulted her. I don't have to say SA. This isn't TikTok. He sexually assaulted her. And that was like a whole storyline for like an entire season, frankly, to the point that it got old. And he has sued her, saying, that's not true. And I'm a public figure. And you're running around telling everybody that I sexually assault people. And I absolutely didn't. And if anything, you were the one who was into me. And of course, it's created a pretty good storyline for the show because people love to have these kinds of real life disputes. But she has now filed one of these pro-speech motions to say, I said something about my own personal experience, and I talked about it on a TV show that you are on sometimes about something that happened to us while we were filming another TV show. I'm allowed to talk about the things that happen on TV shows when we are on reality television. You shouldn't be able to sue me for that. That is my free speech. And that one, like I said, is probably the closest to what these laws were first intended to do, which is you can't stop me from telling people about my own life and my own experiences simply because you do not like it. The law should look really disfavorably on that, and the court should throw it out as soon as humanly possible. So I understand where she's coming from. I think the challenge that she's going to have, and I'm expecting what the response is going to be, is you're making money off of this. This is not just, I was telling this to my friends or I was telling it to the police. You use this as a storyline on a reality television show for which you get paid. So the more you talked about claiming that I did this to you, the more money you made. And that is a problem. I think that creates a really interesting question about, is it free speech? If you were talking about it on a scripted television show, it absolutely wouldn't be free speech because it's not your words. So it might raise a really interesting issue about how real is reality TV. But you can see from her case, from the baby reindeer case, and from the Pitt case, these pro-speech laws are being used a lot in the making of entertainment. And I think that the reason we're seeing it so often is that more and more entertainment is being made because of content creation and because of reality TV. HBO is like the traditional entertainment creator, right? And Netflix is not new anymore. They were the first big streamer. But everybody's making content all day long, myself included. And there has not really been much legal movement on the idea of how much content is protected speech. And so I think some of these motions are being filed. They're probably going to tee up these issues. Eventually, we're going to have something get all the way to a state Supreme Court or something. Because the question of whether entertainment companies can stop lawsuits simply because they're making entertainment, I think is a very interesting question that is not at all the purpose for why these laws were passed. I think these laws were passed to make sure that big, powerful people and big, powerful companies didn't file lawsuits to shut people up. But now we have it flipped, where little people are filing lawsuits to keep big companies with lots of money and lots of lawyers from saying things about them they don't think are true. So hopefully some of these go somewhere, but that's what these things are about. And I do think there is a fundamental question about why do we need this kind of protection in the first place? Who needs it and why do we need it? Right? Is there something inherently wrong with the civil system if we need to have these kinds of laws in the first place? Why should somebody be able to sue simply because they don't like something that someone said? Right? It's this constant balance between having the right to utilize the courts. We all have the right to utilize the courts in this country. That's part of citizenship. It's even part of residency. It's what our taxes go to. We should all have access to the courts. But where is the line of, well, but you shouldn't be able to sue for that? And because free speech is so sacrosanct in the United States, and it is so hard to sue over things that people say, I think we really have to start looking at what those are, and how we want them to work in this next phase when everyone is online saying everything all of the time. Do the way that the laws have been built still work? Do the standards for defamation still work? You know, do we need more laws like this that allow cases to be thrown out early? Or should we just craft the original laws different so that people can only sue for certain things from go? What's the right balance? I think it's a fascinating question. I'm going to keep talking about it because I'm fascinated by it. But I think my takeaway from all of these is, and I hope it's your takeaway, at least one of your takeaways too, is that people have this impression that free speech as a concept is about politics. That the constitutional right to free speech is being able to put a sign in your yard or say that you disagree with a politician or vote for who you want or, say you don't like what the government's at protest, right? And those things are all true, but it is much, much more than that. It is much more than that. It comes up everywhere all of the time. And like I said, the more that people are making content and the more that people are trying to find ways to sue people for content, the more it's going to come up. So let me know what you think about those. I know it's a lot to take in, but I really think nomenclature matters. And if you think about it as pro-speech instead of anti-SLAPP, it really does help. The purpose of them is to protect speech. That is easier than they are anti a certain kind of lawsuit. So thank you for joining me on this 9th episode of Allegedly Golden. Please let me know what questions you have, and I will be more than happy to try to answer them. And I will see you next week on the last numbered episode because the drama never stops and someone has to make it make sense.